Of course, any member of Congress may file a bill, provided that he files the bill in his own house. However, the Constitution immediately imposes a limitation on the bills that will be filed and eventually deliberated upon. The Constitution says, appropriation, revenue, tariff bills, bills increasing the public indebtedness, bills of local application, and private bills must originate in the House of Representatives. All right. Immediately then, we should look at Tolentino versus Secretary of Finance and Alvarez versus Lingona. Okay. In Tolentino versus Secretary of Finance, we have the bill on the value-added tax filed in the House of Representatives. Let us call it VAT 1. Considering that a bill imposing the value-added tax is a revenue measure, because the intention is to generate revenue for government. That's why they are thinking about increasing the VAT. All right. Therefore, because it is a revenue measure, it is necessary that it should originate in the House of Representatives. But what happened in Tolentino was that even as a congressman filed a bill on VAT, a senator also filed with the Senate his own version of a bill on VAT. We call it VAT 2. After the House of Representatives had deliberated and approved VAT 1, when VAT 1 was transmitted to the Senate accepted VAT 1, of course, but put it aside. And the Senate deliberated on VAT 2, which was originally filed to the Senate. That is the reason why Senator Tolentino went to the Supreme Court and said, the VAT law that eventually was passed and implemented is unconstitutional, because even only the Senate version of the bill did not originate from the House. That bill that the Senate approved originated in the Senate, because the bill that originated in the House was set aside by the Senate. Sabi ng Supreme Court, remember what the Constitution provides is that these bills originate in the House of Representatives. The Constitution does not say the law should originate in the House of Representatives. It does not say that an appropriation law, a revenue law, a tariff law, a law giving increasing public debt, or a law of local application, or a private law shall originate in the House. It says bill. Bill lang ang mag-originate, not the law itself. Accordingly, the Supreme Court said, the Senate, because under the Constitution, it has the power of amendment, the power to amend. The Senate could therefore, after it receives the revenue measure from the House of Representatives, set it aside and talk about and approve a completely different bill. If it approves a completely different bill, it is only exercising its power to amend. there can be an amendment by substitution. Besides, that only shows that the Senate says, walang kwenta yun, palitan natin, yan as amendment. That is only an expression of the Senate's power to amend the bill. So, it is within the prerogative of the Senate to completely reject a bill coming from the House and to consider a bill that was originally filed with it, provided only, the Supreme Court said, that the Senate shall not consider the bill originally filed with it until the bill on any basis shall have been transmitted by the House to the Senate. Hindi pwedeng unahan ng Senado. Hintayin ang galing sa House and then substitute the Senate version with that which came from the House. In the case of Alvarez versus Gingona, we have two bills of local application. The bills, one in the House, one in the Senate, the bills converting the municipality of Santiago in Isabela into a charter city. Congressman Abaya of Isabela filed the bill here. Senator Gerson Alvarez, who himself comes from Isabela, filed his own version of the bill there. And so, as long as the Senate awaits the action of the House of Representatives. Kasi, if the House did not approve that one, or Isabela 1, or no, Santiago 1, then there is nothing to transmit. In that case, the Senate cannot, on its own, deliberate on the revenue measure or the bill of local application that was originally filed with, because it can exercise only the power to amend with respect to measures or bills that are on these subjects. Pero kung na-approve na dito pagka-transmit sa kanila, the Senate has plenary authority to substitute its own bill for a bill coming from the House. So there is no violation. So 2 points class. Una, what the Constitution provides is that the bill originates in the House. It does not say the law should originate in the House. Second, the Senate's power to amend is plenary. Its only limitation is that it must await the bill transmitted by the House. If the bill is an appropriation revenue tariff, one increasing the public debt, of local application or a private bill. Alright. So, each member of either house will now file his bill with the house to which he belongs. Okay? Where does he file this? Technically, he files it with the Secretariat so that the bill is numbered after it is filed. But then the Constitution again comes in and says, the bill must embrace only one subject to be expressed in the title there. This is supposed to prevent what is known as a hodgepodge or log-rolling legislation. Hodgepodge or log-rolling legislation is a bill or a measure that contains many subjects so that it will generate more than enough support from the members. Kasi tatanungin ang isang member, anong gusto mong idagdag natin dito? Anong gusto mong idagdag natin dito? Sige, isama na natin lahat yan dito para marami na tayong sponsor, tayong na-sponsor. Okay. It is also intended to prevent fraud on the legislature. Dahil when you read the title of the bill, you are made aware what the subject matter of the bill is. And so, hindi ka palulusutan ng mga iba-ibang klaseng bill. And then, of course, it is also intended to apprise the people, the public, subjects of legislation. We have a new decision involving one of the provisions in Republic Act 9006, electoral reforms in 2001. This is a case filed by former Governor and former Congressman Rudy Fariñas of Ilocos Norte. I agree with Fariñas on his observations. He was a member of the House of Representatives that passed this bill. Pero kasi, March 9, 2001, towards the end of the sessions already, there was the euphoria generated by the austerity era. Doon sa House, yung mga pro-Gloria, masyadong ganadong-ganado, ay, hindi na binabangsa ang bill. Sinabi na pare, si Presidente nagsabi nito, si Presidente kailangan daw approve po. Ano yan? Yung mga amendment sa election. Sige, approve, kung approve, hindi natin ng mabuti. One of those bills, one of the provisions in that law was the repeal of Section 67, I think, of the Omnibus Election Bill, which provided, it used to provide, that an elected public official who files a certificate of candidacy for a position other than that which he holds in a permanent capacity, or for President or Vice President, shall be deemed ipso facto resign from the elected public office he holds. Ito. So, if you are a public officer, an elected public officer, you run for re-election, you do not resign. Or, if you run for president or you run for vice president, you do not resign from your position. But if you run for any other office, then you are automatically considered to resign from the elective office that you hold. In 9006, tinanggal ito. Repeal. Kaya pumasok siya nun. Sabi niya nun. Hindi ko matandaan yan, sabi ni Rudy Fariñas. Hindi ko matandaan na pinag-usapan yan kung sa House. Ako natandaan ko personally, nandun ko. Kasi kinausap ko pa yung isang aming congressman sa isang distrito ng Samar. Graduating siya. Ang wife niya ang kanyang pakakandidaturin. Kasi hindi siya naniniwala ng political dynasties. Wife niya, pakandidaturin niya. For position ng Congress. Pero, even then, we knew na makakalaban ng wife niya yung incumbent city leader. Incumbent city leader. Isipin niya. Pinausap mo siya, oo. Pare, ikaw itong ikot ng ikot dito, sinasabi mo na si Presidente ang may gusto nito. Tingnan mo itong ano na ito. Would you like this? Your wife will be running against the incumbent city mayor, and he does not have to resign from city mayor. And the city counts with about 65% of the total number of votes of the entire district. Hawak ng mayor ng city, 65% ng votes ng buong distrito. Baka madisgrasya ang misis mo. Hindi, pare, wala tayo, kayang-kaya namin. Resulta sa eleksyon, nanalo yung city mayor by 143 votes. Nung magsalita ang city mayor doon sa off-taking, sabi niya, hindi makalimutan yung aking bid, 143, that's I love you. Yan. Sabi ni, that's why, in the case filed by Rudy Fariñas, he said, that provision, in fact, the law is unconstitutional. Because there was no mention at all in the title about the repeal of that law. Actually, his greater challenge was that provision repealing Section 67 of the Omnibus Election Code is a rider. It's a rider. But riders are not talked about in bills or elections, etc. You talk about riders in general, in appropriation bills. And so the Supreme Court rejected this contention, and even the contention that this was an invalid law because the title did not at all make any mention about the repeal of this. Ang hindi namin nakita doon sa 9006, yung pag-increase ng income requirement ng municipalities before they are converted into cities. Yun. Because that bill, that amendment really, that thing really was surreptitiously inserted into the measure. Talaga naman yun eh. Kasi isipin niyo naman, chartered city, yung component city, 100 million na ang income requirement ngayon. 100 million. Highly urbanized city, 50 million. Province, 20 million. Kasi hindi ginalaw yung province at ang highly urbanized city. Ang pinili lang, isililit lang yun para hindi marami ang maging city. Para mag-block yung maraming municipalities aspiring for city hall, because there are many bills in the House of Representatives asking for the conversion of municipalities into cities. Para hindi makalusot yung mga yun, isinilit lang. Hindi naman tinignan na kung anong epekto sa iba. Imagine how absurd it is for an ordinary component city required 100 million, pero for a highly urbanized city, 50 lang. And for a province which certainly is very much bigger, 20 million lang. Kaya hindi ibibigay sa maritime itong mga income requirement sa kasi kitang-kita na ang law as it is now is absurd. Anyway, yan. Okay. So, but class, of course, you have this, an act prescribing the civil code of the Philippines. Yan, kitang-kita na. Maraming subject ang civil code. Pero, civil code naman. Alam mo naman na maraming subject matter talaga. What perhaps many people do not know is that the bill kamukha ng challenge sa Makati. Ang title ganito, an act converting the municipality of Makati into a highly urbanized city to be known as the city of Makati and for other purposes. Halos lahat ng bill meron yun, and for other purposes. That phrase, and for other purposes, does not at all violate the Constitution. And it does not, it does not prevent, it does not really foist fraud upon other members. So that class, what does this constitutional provision mean? It means now, in accordance with decisions, that the subject of the entire bill may be a general subject. 9006 was supposed to be an amendment, an act to amend article, etc., section, etc. of the Omnibus Election Code, or an act to provide electoral reforms, etc. Ganyan ba? So maraming amendments and for other purposes na naman. Yeah. As long as there is a general subject matter expressed in the title. Then there can be as many particular subjects as there are in the bill, provided that these particular subjects are germane to the general subject matter expressed in the title of the bill. And second, the bill's title does not have to be an index of all that the bill contains. In Mariano, West Comelec, yung challenge na isa, aba, you are creating 2 districts in Makati. That is not even found in the title. So this is unconstitutional. Sabi ng Supreme Court, no, this is related to the creating of, to the conversion of the municipality to a highly urbanized city. Kasama na ito dito sa and for other purposes. Because the title does not have to be an index. Imagine, if it is a long bill and you have to place in the title lahat na lang na naroon sa bill, mas mahaba pa ang title mo. So that is what is being considered. So yun, again, 2 aspects yun. General subject, to which all particular subjects are germane, and then the title is not required to be an index of all the contents of the bill. Alright. So, the bill is filed. It is numbered. Then it is calendared for first reading. The Constitution provides, no bill shall become a law unless it passes 3 readings on separate days. Okay. 3 readings on separate days. Ibig nang sabihin to, because this was a practice under the 1935 Constitution when there were only 100 session days a year. Sa Congress, 100 session days lang. First 98 days, yung mga congressman, mga senador, nandun sa casino lang, etc. Tapos on the 99th day, they wake up, aba, bukas pala, wala nang session. Tawag ka sa staff, oy, malapit na mag-eleksyon, tago kayo, kailangan na mag-file tayo ng mga bill. Para medyo naman maipakita natin na meron tayong bill na na-approve. Sabi na staff, sir, paano naman, ano mo lalagay natin? Basta siya no! Like what, sir? Like what? Like, we have a high school named Imelda. Palitan natin, an act to change the name of Imelda High School to Corazon High School. Now, to Gloria High School. No. Yan, okay. Tapos, hard-carry niya yun. Number, tapos, hintayin niya, basahin na kagad, first reading. Tapos, tatakbo na doon sa committee. Pare, gawa niyo na ng committee report ito. Kaya ito, ginawa na kayo ng committee report ng aking staff, pero namin na lang. Ganon. Tapos, yun, in 2 days time, even on the last day, they could then have bill. That is the reason why under the Constitution, it is expressly provided that the bill must undergo 3 readings on 3 separate days. On separate days. Except Tolentino versus Secretary of Finance. Except when the President certifies to the urgent passage of the bill in order to meet a public calamity or emergency, in which case you do not have to comply with the separate days requirement. You can have your bill undergo 3 readings on the same day, as long as the bill is certified. Even if the Constitution says that President certifies to the urgent passage of the bill in order to meet a public calamity or emergency, miski yung hindi naman public calamity or emergency. Kasi si Presidente kuminsan pag-depende na rin sa lumalapit sa kanya. Ito. Ma'am, kailangan kong i-convert ang aming state college into university. Wala nang panahon ko, pero kailangan ko. Punta rin ma'am, pwede ba certified? Depende lang yung parang, pwede certified. How can the conversion of a college into university meet a public calamity? Pero nobody questions anymore. Nobody in Congress questions as long as the bill is certified by the President. Pag sinertify ng Presidente, mabilisan. Okay. So, what happens during the first reading? During the first reading, only the title and the number of the bill are read. After which the speaker, or whoever is presiding, will refer the bill to the appropriate committee. The appropriate committee or committees, kasi kung minsan ang bill has to be taken up or discussed by several committees, by 2 or even more than 2 committees. Okay. So yeah. The committee work is really the most important, it's really the most productive, the most fruitful of the work in legislation. It is during the committee hearing na talagang hinihimay ito. It is during the committee work that you invite experts on the subject of the bill and you listen to them. You invite people who will be affected by the bill if it should become a law and ask for their opinion. What is your position on this? What is your position on this? Etc. And then, the committee's power over the bill is also plenary. The committee can just say, walang kakwenta-kwenta, let us kill the bill. A bill can be killed in committee. What happens to the bill if it's killed? The bill dies. Okay. Or the committee can simply sit on the bill. Pabayanan na hindi mo lang pag-uusapan. That's why, ang committee chairman, malakas din kung malakas na committee ang hawak mo. Kasi, yung mga may interest naman, pare, yung bill ko naman dyan, pag-usapan naman natin. Yun. Then, of course, the committee can also consolidate all bills on the same subject and come up with a substitute bill, integrating the good features of the various bills on the subject. And then, the committee can even draft all of those bills and decide to frame or design a bill on that subject, which is denominated as a committee bill. Then there is voting in committee on whether the bill shall be approved by the committee. If the committee approves the bill, then it is reported out. The term is to report out a bill. The bill is reported out by the committee. What do we mean by that? The committee prepares a report, a committee report, addressed to the House now, asking the House to approve the bill attached to the committee report, which has been approved by the committee. This is, of course, sent back to the office of the Speaker technically, but it really goes to the Majority Leader, because the Majority Leader is the one who's in charge of arranging the calendar for second reading. Considering that there are so many committees and so there are several committee reports, ang Majority Leader, and that is why the Majority Leader is very, very powerful in the Houses of Congress. Because he determines when your bill will be debated upon, when your bill will be discussed on the floor. Kung kalabang ka ng Majority Leader, hindi ka your bill will not see the light of day. Tapos yun. So that's it. Ika-calendar for second reading. During the second reading, the entire bill is read, and then debate on the individual provisions ensues. So, somebody sponsors the bill on the floor. The sponsor is normally the principal author of the bill or the chairman of the committee that submitted a committee report. Or nagtutulong-tulong na lahat. Imbis na wala namang controversy, yung talagang, kay kamukha nung a bill changing the name of the high school in Barangay Gamo-Gamo, municipality of San Juan, and etc. into Gloria High School. Wala namang makikialam yan sa inyo. Yan, hindi lang basta sasabihin na lang ng majority leader pag patawag niya na second reading would be explanatory note attached to the bill be considered as sponsorship speech, and that nobody has manifested any intention to interpolate, nobody has manifested any intention to amend, nobody has. So, after all that, the majority leader says, I move that the period of amendment, the debate, amendment, etc. be considered terminated. And so we ask that we vote on second reading. Tapos na kaagad. Pero yung mahihirap na bill, yung mahaba ang debate, etc. Mahaba ang debate niyan, maski sa amendment. Kasi after the interpellation, now comes individual amendment. If you remember the chamber, you propose an amendment. The sponsor or the committee chair who sponsors the bill on the floor will tell you, yes, or I accept the amendment. Sige, accept it. The amendment will be incorporated into the bill. Pag hindi in-accept, hindi. But the proponent of the amendment may also move that the body vote on this amendment. In which case, if the body votes in favor of the amendment will be carried and incorporated in the legislature. After this, then the bill will be submitted for approval on second reading. Normally, the voting is merely by viva voce, etc. All those in favor say aye. May sisiyo aye. All those against say nay. Yun din mga tao. Sila hindi. Walang ginagawa. Walang magawa mo. Because hindi naman sila nakikinig kung ano yung nila. Pero ang chair na alright, the ayes have it, the bill is approved on second reading. Okay. Yeah. Arroyo versus Indonesia. In Arroyo versus Indonesia, Joker Arroyo went to court to challenge the constitutionality of the sin taxes, saying that this tax law was not approved in accordance with the rules of the House. Not in accordance with the rules of the House. Besides, in his motion for reconsideration, he spoke of, in fact, when this was approved on second reading, there was no quorum. Alright. The Supreme Court said, diba, napag-usapan na natin ito, that the Supreme Court said, no. If we are to assume that what you are saying is true, Mr. Joker Arroyo, if you are not joking, if what you say is true, that the approval was made in violation of rules of the House, then we also assume that the House at that point decided to change the rules because the House can do that. If it decided to approve this in a different manner from other bills, then it can do so because it can always change the rules. It has plenary authority over them. And of course, on the quorum, we also talked about this already. The Supreme Court said, you cannot raise the question of quorum every time, especially if at the beginning of the session there has been a roll call and the quorum was determined to exist. Okay. After the bill is approved on second reading, then printed copies of the bill in its final form. So, the bill shall be printed in its final form, and the printed copies must be distributed to the members of the House at least 3 days before the third and final reading. Except if the President certifies. If it is a certified bill, then you do not have to wait for 3 days. The printed copies of the bill in its final form may be distributed on the very day that the third reading will take place. Okay. So it's calendar for third reading. During the third reading, only the title and the number of the bill are read, after which a voting shall take place, and the results of the voting shall be entered in the legislative journal. Normally, both houses now, today, there is nominal voting. Nominal voting. Roll call vote. Yan ang sinasabi natin na roll call vote. Isa-isa. Pero again, dun sa mga bill na wala namang controversy, wala namang nagano, mabilis ang roll call niyan ng Secretariat. The Honorable Congressman Abad Subiri, Speaker 175 voted in favor. Lang yun. Pag mga importanteng measures, of course, pinag-debatehan talaga yun. Because during the voting, many of the members in fact asked for time to explain why they are voting this way or the other way. For posterity, of course. So that when he runs for re-election, he can show, this is my stand to the measure and this is how I explain it. So, okay. Alright, so after the bill is approved on third reading, then it is authenticated by the Secretary, signed by the Speaker, and sent to the other House, where it will undergo the same procedure. First reading, referral to committee, report out by the committee, second reading, amendments, debate, amendments, and then vote on second reading, printing of the copies of the bill, distribution 3 days before third reading, nominal voting. Yun. Thus, however, in very important measures, such as in the VAT law, even as the House approved its version, VAT 1, the Senate approved another version, VAT 2. Completely different from that approved by the House. When there are two conflicting versions of the measure approved by the Houses, then these two conflicting versions shall be sent to a bicameral conference committee. Wala na ito sa konstitusyon. Bicameral conference committee shall be composed of members of the Senate and members of the House, chosen by their respective houses, in order to sit in this committee and thresh out the differences between the two conflicting versions of the bill and to arrive at a reconciled version. It is not unusual that when the bicameral conference committee ends, the bicameral conference committee has a third different version of the measure. And so, back to Tolentino versus Secretary of Finance. Tolentino said, ano ito of bicameral conference committee, there is no such thing in the Constitution. And by giving the bicameral conference committee so much power, even to the point of the bicameral conference committee approving a completely different version from that approved by the House and by the Senate, you have created a third house of Congress. Therefore, unconstitutional, sabi ni Philippines. The Supreme Court said, no, of course not. It is not unconstitutional. This is legislative practice in all democratic states which have bicameral legislatures. Because where there are two chambers of the legislative body, these differences cannot be avoided. Accordingly, there is need for a bicameral conference committee to thresh out the differences. Then, when the bicameral conference committee agrees on this version, then the bicameral conference committee report, along with a copy of this version, will be sent to the two houses. The two houses will deliberate on the report and then vote on the third reconciled version of the bill as proposed by the bicameral conference committee. Both the voting shall be as if on third reading. Nominal voting entered in the journal. It will be as if this is being voted upon on third reading. Okay? If approved, then the bill is deemed approved by the House. What is the vote required to approve a bill by each of the houses? As a rule, class, a majority of those present, provided that those present constitute a quorum, is sufficient to approve the bill, unless the Constitution requires a different vote. Such as, in the case of a law or a law that grants a tax exemption, the Constitution specifically provides that such must be approved by a majority of all the members of each of the houses. Ordinarily, there are 24 members of the Senate. 13 would constitute a quorum. So, 13 lang ang present. A vote of 7 is enough to approve the measure. Kung 13 lang ang present. However, if it is for a tax exemption, you need at least 13 votes. Okay. Once approved, the measure is then signed by the secretaries of the houses, authenticated by the secretaries of the houses, signed by the Speaker and the Senate President, and then sent to the President of the Philippines. If the President approves it, okay, it becomes a law. If the President does not act on it within 30 days from receipt, then the bill lapses into law. It will become a law through the inaction of the President. If the President disapproves the bill, then as we said earlier, the President must write down the objections that she has to the bill. And these written objections is known as the veto message. Having prepared the veto message, this message along with the bill will now be returned to the House of Origin. Returned to the House of Origin with the veto message. The House of Origin has the option whether or not to override the veto. The term class is override. Whether or not to override the veto. And for that purpose, the House of Origin must obtain at least a vote of 2/3 of all the members of the House, after which a similar vote shall be required from the other chamber. If the vote of 2/3 at least is obtained from both of the houses, then the bill becomes a law because Congress has overridden the veto. Thus, in the bar exams, kung may question na how does a bill become a law? And it is worth only 1%. Then, in all probability, ito lang ang tinatanong. Talking of an approved bill already by Congress, ito na lang ang tinatanong. Pero kung 10% lang, how does a bill become a law? It's plain, 10%. Ang ibig sabihin nun, mula sa umpisa, i-store mo yun. Huwag nyo lang i-sabihin mo yung mga I at 9, at 8. Pero kung ako kasi ang notice that in the 3 instances when a bill becomes a law, the bill has to be sent to the President for the President's approval or inaction or disapproval, but the disapproval of the President is overridden by the Houses of Congress. There is a 4th way when a bill becomes a law. Diba? Nabasa niyo. Kailangan po na tayo mag-usap na tayo ng maigi dito. Itong ating pinag-uusapan dito, kayo ba naman ay nagbabasa doon sa inyong bahay bago kayo pumunta rito? Para magkaintindihan naman tayo ng paligid. Hindi ko lang ko, wala ang danaan. Alright. I am referring to a situation where a bill becomes a law even without referring the bill to the President of the Philippines. Is there such a thing? Yes, of course there is. One situation. In the next article, when there is a vacancy in the office of the President and Vice President, the Constitution says that at 10 o'clock on the 3rd day from the time the vacancy occurs, Congress shall convene without need of a call and in 7 days pass a bill calling for the holding of special elections for President and Vice President to be held not earlier than 45, nor later than 60 days from the date of such a call. The bill, once approved by the 2 houses of Congress, automatically becomes law. The bill is deemed certified by the President, even if it does not carry the certification of the President. The Constitution says it is deemed certified. It can be passed through 3 readings on the same day. And the bill, upon approval by the House and the Senate, automatically becomes law and cannot be set aside by the President or the acting President. Why? Because if it is to go through the usual process, yung acting president mo might already enjoy na acting as president. Pag sinabi ng Congress, eleksyon na tayo, hindi, ka. Mukhang masarap pa naman presidente ng Pilipinas. So that is it. That is the fourth instance. And notice that this is provided by the Constitution without any action, inaction, interference by the President of the Philippines, or the acting President of the Philippines. Before, alright, tapusin lang natin to, then we go back to dito. So when approved by the President or the bill becomes law, when does it take effect? That is mastered. You mastered that already in civil law. That is the first thing you learn in the civil code, when laws take effect. After 15 days following the completion of publication, the decision is set for the newspaper of general circulation unless a different date is provided for in the law itself. Merong Veterans Bank case that creates the impression that of course you have mastered this already in your, that creates the impression that a bill, a law can take effect even earlier than the lapse of 15 days prior to, from publication. Because the law speaks unless another date is provided therein. Although I really would like to believe that when we speak of another date, it is another date other than 15 days after publication. Like the local government group, by express provision, this was passed in 1991. It was published in 1991. But it took effect by express provision of the law on January 1, 1992. Months after the publication was completed. Alright. Plus yung veto lang. Una, no partial veto. Una, no pocket veto. There is no such thing in our jurisdiction as a pocket veto. Why? A pocket veto takes place when the bill is given to the President and the President simply puts it in his pocket and forgets about it. That's a pocket veto in other jurisdictions. But in our jurisdiction, if the President does that, then the bill lapses into law after 30 days. Okay. Second, no partial veto. As a rule, the President cannot disapprove a part of a bill while approving the rest of the bill. It has to be complete disapproval. When a bill is disapproved, then it has to be completely disapproved. Except in appropriations, revenue, and tariff bills, where the President may veto specific items without affecting the other provisions of the bill. When the President, however, partially vetoes an appropriation measure because he is allowed to veto items without affecting other provisions of the measure. Remember only, class, that especially in a general appropriations bill, the President can veto only items. It has to be an item veto not simply a line veto. So it is an item veto and not simply a line veto. You see, under the General Appropriations Law, item, say, for flood control in the Pasig, Marikina, Pasig, so much amount appropriated. And then below that, maybe a breakdown of the various items that have to be spent for or spent on various items. In a general appropriations bill, the President has to disapprove the entire item, not simply lines. Okay. Then, of course, plus the matter of a legislative veto. Legislative veto. The Supreme Court said there is a legislative veto, rather. A legislative veto is a mechanism by which Congress interferes with administrative or executive action taken under a law or a bill that has become a law. Go back class to separation of powers. Separation of powers. Legislative department makes laws. Executive department executes the laws. Executing the laws means administering, enforcing the law. Enforcement and administration of laws. So, after the law is passed by Congress, as a rule, Congress does not have a hand anymore in the enforcement and administration of the laws. O paano pa bakit? Kasi tapos na yung papel. Ikaw ang policy, ikaw ang gumagawa ng policy, ikaw ang gumagawa ng batas. Yung pag-implement, pag-enforce ng batas, kami na yung executive department. But through a scheme, by inserting a provision in the law, it is possible that Congress may still interfere even in the matter of the enforcement and administration of law. One such example was pointed out by the Supreme Court in the case of Philippine Constitutional Association versus Salvador Enriquez. In the General Appropriations Act for 1994, there was an item of, say, no? Hindi ko alam kung magkano. Say, 2 billion pesos, which will be spent for the modernization of the armed forces of the Philippines. Spent for modernization of the armed forces of the Philippines. So, Congress had already finished with its role of passing the appropriation measure by authorizing the release of 2 billion from the public treasury for this given public purpose, the modernization of the armed forces of the Philippines. Pero palibhasa mga congressman, sabi ko malaking billion na yun. Lagyan natin ang parang control naman dito. So, they added a provision. Provided, however, that any expenditure of that amount shall be subject to disapproval by Congress. Any expenditure taken from that amount may bibilhin na tangke o helicopter para hindi na kamukha nila Mr. Punong Bayan. Helicopter o ibilhin. Before any such expenditure, however, there is, that is subject to the disapproval. That is in the negative. It could also be in the affirmative. Sabihin, provided, however, that before any expenditure of any portion of the money is made, the approval of Congress shall first be obtained. So ano ang ibig sabihin nun? Talagang gusto makialam ang Congress doon sa pag-spend na hindi nakasama yun sa appropriation. Hindi nakasama sa trabaho ng Congress yun. Pero gusto rin nila nakasama sila yun. Mas magandang trabaho yun kaysa sa magagawa ka lang ng batas. Pero anyway, that is it. And so, the Supreme Court said, a legislative veto is of doubtful constitutionality. But the Supreme Court stopped short there, did not declare this provision unconstitutional for violating the separation of powers doctrine. Sinabi lang ng Supreme Court, this provision is, however, an inappropriate provision in the general appropriations law. It is inappropriate. It should be contained in a separate substantive law. And so, because President Ramos had vetoed that provision, the Supreme Court said, well, the veto may stand because we are saying that that is an inappropriate provision anyway and should be contained, if at all, in a separate substantive law. Okay. I suppose that should take care of. Okay. Dalawa na lang na importante. After that, madali naman yung ibang powers ng Congress, na constitutional power. Okay. The next power, which entails, is really still the exercise of legislative powers, is the power of appropriation. The power of appropriation. The power of appropriation is the power of Congress to authorize the release of public money from the national treasury. This is necessary because the Constitution explicitly provides that no money shall be taken from the public treasury unless pursuant to a valid appropriation. That is why there is need for an appropriation. In the case of Commission on Elections versus Judge Quijano Padilla and Fotokina, class, you will remember that matagal na natin pinag-uusapan dito sa Pilipinas ang automated elections. Awa ng Diyos, hindi pa rin nagagawa. Okay. So, Congress directed the COMELEC, mag-automate na tayo. Kailangan na natin yan. And for this purpose, we are appropriating 1 billion pesos. Congress, nag-appropriate ng 1 billion. COMELEC, ayan, 1 billion. So the COMELEC prepared for the automation and said, siyempre, we will have to bid this out kung sinong provide ng mga machines, etc. From the counting machines to the whatever, reading machines, counting machines, siguro kailangan din ng cheating machines. Lahat yan. Okay. COMELEC said ang 1 billion kukulangin po. Kukulangin. In the COMELEC itself, they were able to raise 200 million savings, giving a total amount of 1.2 billion. The COMELEC organized, of course, a PBAC, etc., lahat, and then bidding committee, and then a bid out. The lowest bidder, at least the winning bidder declared by the COMELEC was Photokina. Ang bid ng Photokina, 6.3 billion. And Photokina was awarded the contract. But for one reason or another, of course, una, the major reason was wala namang contract talaga. COMELEC was not keen on implementing the contract immediately. Kasi wala namang contract talaga. Photokina went to court, RTC, on an action for specific performance. Specific performance, may kontrata. May kontrata tayo. Meron akong kontrata. Ako ang awardee nitong kontrata na ito. So all I'm asking is that the other party honor his commitment under the contract. Specific performance, you know that very well in your remedial law. So yun. The trial court ruled in favor of Photokina on the basis of civil law principles. May kontrata kayo, meron kayo wala namang rason na i-rescind ang contract. So, implement. COMELEC went up to the Supreme Court because it could not implement. It did not want to, and it could not. And the Supreme Court said, there is no contract. There's no valid contract at all. For in the first place, sabi ng Supreme Court, what was appropriated? The money that COMELEC had was only 1.2 billion. When it received the bid, lowest bid of 6.3, the COMELEC should have rejected all bids. And it cannot approve a bid for more than what the money that it had. Sabi ng Supreme Court. In fact, that is the reason why there is need for an appropriation coming from Congress, sabi ng Supreme Court. This is also intended not only to provide the legal basis for the release of the money, but also to ensure that the government agency spends within the limits provided by Congress. In this case, 1.2 lang ang korta, bakit mag-approve ng kontrata na 6.3 billion? And so the Supreme Court said, wala, there is no contract. And so the Supreme Court reversed the trial court. Photokina cannot demand a specific performance. But that is why, class, the so-called power of the purse, in government is vested in Congress because of its power of appropriation. Of course, in our homes, the power of the purse is vested in the mind. While the gentlemen hide a little sometimes from the light. Okay. Kaya, then we go to just mabilisan na lang. First, what are the two appropriation measures or laws that may be passed by Congress? We have the General Appropriation Law, which is of course based on the budget that is submitted by the President within 30 days from the opening of the regular session of Congress, and which provides for the financial requirements for the operation of government for one fiscal year. And the second is a special appropriations law, which is a measure intended to provide the money for a specific public purpose. There are two extra constitutional limitations on all appropriation laws. First, that the appropriation must be for a public purpose. I don't think that we need to explain this anymore. for a public purpose. Kaya lang, nung unang panahon pa ito, kasi nung unang panahon na mahilig yung mga congressmen, mga maglalagay na pag nagsisimento ng kalsada, mayroong malaking This is where your taxes are being spent. Diba? Nung panahon na yun. Pero kasi noon kuminsan magpapagawa ng kalsada, nagpapaayos din si Mayor ng mga bahay. Kaya nililipat na ng tao. This is where your taxes are being spent. Sa bahay ni Mayor. So that's the public purpose. Second, the amount appropriated must be determined or at least determinable. In obligations and contracts, you recall a sum determinate, an amount determinate, specific, may amount talaga, determinate. Or determinable, where, for instance, there is a provision to the effect that no expense, the expenses shall not exceed the amount of 1 million pesos. So, even as the expenses may be less than 1 million, where there is a ceiling fixed at 1 million pesos, that makes the amount still determinable. And so, in the case of Gingona versus Calage, Senator Gingona went to court to question a provision in the General Appropriations Law for 1990. That provision that he contested was the debt service provision. In the General Appropriations Law for 1990, there was an item to the effect, such amount as may be needed to cover payment of principal, interest, taxes, and other banking charges due for the year 1990. Walang amount na nakalagay sa law. Kaya Gingona went to court and said, this is unconstitutional, this is invalid, because you do not have an amount determinate or at least determinable. Sabi ng Supreme Court, valid pa rin, valid to. This is valid. Because even if there is no exact amount, no amount mentioned, it is easy enough to arrive at the amount. Easy enough to arrive at the amount by simple arithmetical or mathematical computation. After all, it is easy to determine how much the principal due will be, how much the interest that has to be paid will be, how much taxes and what other banking charges have to be paid. Sabi ng Supreme Court. So, that makes the amount still determinable. Because it can be arrived at by simple mathematical or arithmetical computation. With respect to spatial appropriations measure, there are two spatial constitutional limitations. Number one, the law itself must specify the public purpose for which the expenditure will be made. Public purpose na naman. Second, the law must be accompanied by a certification issued by the National Treasurer that there are funds available for the purpose. Or, in the absence of such a certification, that the law itself contains a revenue measure. Again, yung second requisite, certificate as to availability of funds. Those of you working in government know this. That when there is something, a voucher, for example, sought to be approved in payment of something purchased, there is to be a certification as to availability of funds. In the national level, this certification is supposed to be issued by the National Treasurer that there are funds available for the purpose. But it may turn out that there are really no funds available for the purpose. When there are no funds available for the purpose, the only way that a special appropriation law will be valid is if the appropriation law provides the manner the law itself provides the manner on how the amount is to be raised. Yung sinasabi sa Constitution, revenue measure contained therein. Nung kami mga nag-aaral pa ng dito noon, mahilig din kayo nanood ng sine, of course, ng mura pa sine. Mura pa sine. Mga first class theaters noon sa orchestra 1 peso 20 centavos na bayad. But even then, class, pag nag-uulan, Manila would be flooded. The flooding problem was already there many years ago, and even long before us, of course. And so the government wanted to put up an effective flood control program, a project that would effectively control flooding in Manila. But they had no money. So anong ginawa nila? Nagpas ng law kung ibang po nilagay doon sa law. So the amount shall be raised from money that will be collected by increasing the admission fee in all movie houses in Metro Manila. Increased by 25 centavos. The 25 centavos will then accrue to a fund which will be used for the construction of the flood control project in Metro Manila. The law would be valid because it provides, in itself, it provides the manner on the manner of raising the funds that will be needed for the public purpose. Yun. Okay. Then class that pwede pa. Let us look at the constitutional limitations on general appropriation bills or laws. First, Congress cannot increase the amount recommended by the President for the operation of government for one fiscal year. So, Congress cannot increase. This does not mean, class, that sa Department of Agriculture, halimbawa, Department of Education, because this is supposed to be under the Executive Department, under the President naman. The Congress can make adjustments here and there for that purpose. But on the whole, cannot act or increase the amount recommended by the President for the entire Executive Department, for instance, or for the entire Judicial Department. Because what is really intended to be prevented here is that Congress play upon the greed of government agencies. Dadagdagan ko ang iyong appropriation. Basta lahat ng aking projects dun sa aking distrito, ayos lang. Ganun na. That is intended to be prevented. Okay. The second constitutional limitation is that the form, content, and manner of preparing the budget, the general appropriations law shall be as provided by law. There is, of course, no question about that. Third, no provision or enactment therein in the general appropriations law shall be embraced therein unless it relates specifically to a particular appropriation item. So, this is what is supposed to prevent riders. Prevent a rider in the general appropriations law. A rider is an inappropriate or irrelevant provision in the general appropriations law, because it does not specifically relate to any particular appropriation item. Alright. The fourth is, of course, that the procedure for the approval of the appropriation for Congress shall follow the same procedure as that for other departments. This is intended to prevent what the Supreme Court calls sub rosa appropriations in Congress. Sub rosa, under the rose or under the table. Fifth, the prohibition against transfer of appropriations. So the Constitution prohibits any transfer of appropriation. In criminal law, you call that technical malversation. Prevent transfer of appropriation, but Congress may by law authorize the President, the Senate President, the Speaker, the Chief Justice of the Supreme Court, the Chairman of Constitutional Commissions, to augment particular appropriation, particular items in their respective appropriations, or the appropriation for the department, with savings from other appropriation items in their respective appropriations. Thus, halimbawa lang, in the 2005 General Appropriations Law, there is an item there for repair of school buildings. Say 100 million pesos for repair of school buildings, which is to be undertaken by the Department of Education. Okay. Projections ito na yung in-repair over entire year mauubos, o at least marami ng buildings ang repair. And then a typhoon comes in March or April. Ano nangyari sa Aurora and several school buildings are blown away by the typhoon. And so government undertakes to repair all of this or to reconstruct, and then July pa lang ubos na yung 100 million. And yet in some other provinces there are schools that really also urgently require funds for repair of school buildings. Ubos na yung item for repair of school buildings. Angal ng angal ng mga tao. Sasabihin ni Presidente, okay, under the law I am authorized to do this anyway. From my social fund, I have savings of another 50 million pesos. We will use the savings in the social fund to augment the school building repair fund so that we can have all the other school buildings undergo repair. That is what is meant by that. In Consa versus Enriquez, kinestyon ito doon sa congressmen. Yung tinatawag sa DBM na realignment. Ito, this happened to me. 2004, January to June, I was entitled to releases on public works funds belonging to my district. For example, in 2004, because the 2004 budget was never passed, we used the 2003 budget. I was entitled to 25 million pesos worth of public works projects to be funded from the public works fund from January to June of 2004. Another 25 from July to December 2004. So, okay. So, submit ako sa BBM ng listing ko. Itong barangay na ito kailangan semento ng barangay road. We need to concrete also a farm-to-market road from barangay A to barangay B, etc. Submitted this. Identified na ang projects. In-approve ng BBM. Nag-release ng tinatawag na SARO. Okay. So, bibin out na dun sa DPWH, leave out. Maliliit lang naman to. If you 100,000 pesos for this, if you 100,000 for that, maybe 1 million pesos for itong isang project nila. Unfortunately, nag-bid out na, nagkano na. Kaya Pacquiao contract, pag maliit lang naman, okay. Hindi na re-release ang contract. Mga contractor ayaw din mag-umpisa dahil it will take months before they can collect. Gusto mo na malaman kung ayaw ng contract. Natapos ang eleksyon, natapos ang June, hindi nag-release ang DBM na kami. Talo ko sa eleksyon. Bagong congressman by July. Ayoko nang pumayag. Ba't yan sa barangay na yan? Nachura yung barangay na yan eh. Ay, yung ang paglalagyan ko ng project, ililipat ko doon sa akin naman. Pinanalunan ko. He realigned this project to some other places. Okay. This will entail a transfer funding. Technically, pwede ito augmentation. Pero, look, why will a congressman do that? Why will he be allowed to do that? He is not authorized under the law to do that. It's the speaker who is authorized. Kaya sabi ng Supreme Court, when that happens, it is the individual congressman who simply points out the items na kailangan i-realign. It is still the speaker who exercises the actual realignment or the actual augmentation of funds. Ganon ang ginagawa. Kaya, valid pa rin daw. Valid pa. Valid pa rin. Now, in 1994, naman, General Appropriations Act. Yun. Merong appropriation of so much amount. And then sinabi ng law na the Chief of Staff of the Armed Forces of the Philippines is authorized to effect augmentation of other items in the appropriation for the Armed Forces of the Philippines. Ramos vetoed that. Binito ni President Ramos yun. Sabi President Ramos, that is unconstitutional. Because the Chief of Staff of the Armed Forces of the Philippines cannot, under the Constitution, be authorized to effect this transfer, augmentation of funds. Only the President of the Philippines, Senate President, Speaker, Chief Justice, Chairman of Constitutional Commissions, and do that. Okay. Number 6 is, of course, the prohibition against appropriation for sectarian benefits. We already discussed this when we discussed the non-establishment clause. We have cases, old cases, Aglipay versus Ruiz on the stamps, Garces versus Estenso on the barangay officials who bought yung phone of their image of their patron saint. We have Manyosca versus Court of Appeals on the expropriation of the birthplace of Felix Manalo. And well, to a certain extent, we have the case of the Islamic Dawa Council versus Office of the Executive Secretary. Then finally, general and automatic reappropriation. Automatic reappropriation. When Congress fails to pass the General Appropriations Law for a given fiscal year, then the General Appropriations Law for the immediately preceding fiscal year shall be used until Congress passes the Appropriations Law for that fiscal year. Today, of course, class, the fiscal year coincides with the calendar year. I don't know. Diba? January to December na rin ang fiscal year ngayon ng gobyerno. Hindi na June, July to June. January to December of the same year. Just two more things. The power of impoundment. The power of impoundment is recognized has been recognized by the Supreme Court to be validly exercisable or exercised by the President of the Philippines. Impoundment is the refusal by the President, for whatever reason, to spend money that has been authorized already or appropriated already by Congress. Alam nyo, nangyari ito nung panahon ni President Ramos. Even in the case of Pinconsa versus Enriquez, there was already reference to impoundment. And the Supreme Court, in fact, recognized that can be done. The Supreme Court made reference to certain provisions of the Administrative Code of 1987 and spoke of what in the Administrative Code are referred to as appropriation reserves. Appropriation reserves. Even as the amount is specified already in the law, 10 million pesos for this particular project, for this particular which this particular agency will implement. Sasabihin ng Presidente through the Budget Secretary, i-reserve mo lang ang 25% dyan dahil kulang tayo ng kwarta. Kailangan hindi mo i-release ng buo. Hindi gagastusin lahat. So, 7.5 million lang ang release. Of course, when the fiscal outlook improves, later, pwede pa rin naman kunin. The agency, the implementing agency can of course request for the release of the 25% that have been withheld or reserved. This is allowed under the Administrative Code of 1987. Plus, so, impoundment and reserves within the power of the executive, except that the President cannot impound or make appropriation reserves or budgetary reserves or whatever else they may be known out of amounts that are supposed to be automatically released to agencies which under the Constitution are granted fiscal autonomy. In the case of Pimentel versus Aguirre, where Nene Pimentel went to court to question precisely what the executive department was doing, hindi inire-release ang lahat ng internal revenue allotment ng local government units. Nag-iiwan ng porsyento. With the promise, of course, that when the fiscal outlook improves, then they will eventually be released. But Nene Pimentel went to court on that, to question the authority of the executive department to withhold amounts that were due local government units corresponding to the local government units' internal revenue allotments. And the Supreme Court agreed with Nene Pimentel and said this is unconstitutional because local government units are supposed to enjoy fiscal autonomy. And when you speak of fiscal autonomy, enjoyed, for example, by the Supreme Court, enjoyed by the constitutional commissions, enjoyed by the office of the ombudsman, you speak of automatic releases of amounts appropriated. And so the Supreme Court said unconstitutional because this violates the fiscal autonomy of local government units. Apparently, class, as I said earlier, of course, apparently this ruling should apply with equal force to all other constitutional offices granted fiscal autonomy. And while we are there, class, considering that we are looking at the Civil Service Commission, the Commission on Audit, and the Commission on Elections, and the Office of the Ombudsman as having been granted fiscal autonomy under the Constitution. We have a very recent decision of the Supreme Court to the effect that the Commission on Human Rights does not enjoy fiscal autonomy. That it is not in the same category as the three independent constitutional commissions. Plus, ang totoo nito, yung ginawa ni Presidente Ramos, 1997, 1998, half of 1998, puro may reserves. Kasi talaga namang he wanted government to be in the red. Not in the red, in the black. Not in the red anymore sana, para meron namang reserve na kwarta. I don't know. Maybe when he thought about this, he was thinking that the Constitution would be amended and that he could run for president again, etc. But what happened was, si Erap ang nakinabang ito. Totoo ito. In the Department of Public Works alone, we learned about this, of course. In July of 1998, I was already a member of Congress. And if there is anything that the congressman must do, he must look for possible sources of funds with which to fund projects that his constituents want him to finish in his district. So yun. We learned, for example, that in the Department of Public Works alone, there was, from the impoundment and the reserves, there was at least 7 billion pesos left by Ramos when his term expired. Lapit kami doon, Bihilar, because si Secretary Bihilar, galing naman kay Ramos din. At yun din ang Public Works Secretary ni Hera. Kakilala naman kami. Kaya Rani Bihilar, Secretary, bigyan mo kunti lang, miski 10 million peso project lang, tapusin lang namin kung ganito. Alam namin may kwarta naman dyan eh. Sasabihin lang ni Secretary Bihilar, kasi gumawa ka ng letter, papirmahan mo lang kay Presidente. Pirmahan ni Presidente, tuloy na kagad kay Budget Secretary Diok mo. Good na yan, wala nang problem na yan. Everything has to be. At si Erap ang malaking nakinabang nun. Mga tao lang ni Erap, hindi naman si Erap. Mga tao lang ni Erap at hindi malalapit sa kanya. There were some congressmen who were able to get from Erap his signature for projects as costly as 100 million, 120 million. Ako hinihingi ko lang 10 million na 1 million. Nabigyan din naman ako for classrooms. 5 million pesos. Kaya nung permahan ng impeachment ko, 5 million lang na naklako. Pero patalang ako. Alright, the only other thing that we will discuss tomorrow class will be, and then we just go through, will be legislative investigation, and then we go through all the other things. And then hopefully, makakatapos tayo ng president bukas na executive department. Eh, dahil gusto ko nang matapos ang constitutional law eh. After president naman, hindi na marami ang ating pag-uusapan. After the president, it will take us only one more day perhaps to finish the rest of the Constitution because we will not take up Article 9, Article 10, Article 11. Yes, we will take them up in public officers and election law. All right, please rise for prayer. May the Father, the Son, and the Holy Spirit come. Glory be to the Father, and to the Son, and to the Holy Spirit. Glory be to the Father,